Thank you so much for being here this afternoon. My name is Carrie Burns. I'm Director of CLE here at the Cleveland Metro Bar Association. Welcome to what has now become the second installment of our Hot Talks discussions on redistricting. Things seem to change by the day, so we're happy to be able to provide these updates with such knowledgeable panelists that we have. Today, this is for CLE credit, so thank you for all of those who have opted for that. Please make sure you can see us and hear us the entire time. And you will be sent a survey at the end of the program. Please make sure you fill that out because that's how we report to the court that you were here. We do want to hear from you today. We want to hear your questions. So please use the chat or the Q&A feature at the bottom of the screen. We will have our presenters give their takes, and then we are going to be pulling questions from the audience. So please have those ready. I want to now introduce Jay Milano. He is with Milano Law and the chair of our Thought Leadership Committee today, which is who puts on these Hot Talks that are held monthly. So Jay, thank you so much for serving as moderator today and welcome.
Morning, folks. Welcome to all. It's good to see all of you here in the snow. About 100 now, I've heard at this point. That's double where we were the last time. And the reasons are clear. To those of you who were here the last time, you know about our speakers. Katy Shanahan, who is the Ohio director of All on the Line. Professor Brian Glassman from Cleveland Marshall. You saw that they are just such a classic example of professional dedication, of enthusiasm for the subject, of expertise. And those of you who are here now will see, I'm sure, those same qualities. And it's about the most important thing going right now. So with that, you don't need me. Professor Glassman, why don't you begin?
Thank you so much, Jay. I appreciate it. My thanks to the Bar Association for inviting me to speak yet again. And it's a pleasure to be presenting with Katy Shanahan as we have before, and to have Jay as our moderator today. I'm going to set up my screen share. Please let me know if you don't see it in just a moment. One more moment, usually takes.
We do.
Okay. Everything look good there? Okay.
Perfect.
Thank you.
There are just some gray boxes on your, if you want to close out of the one pop-up window.
You know, I have them in the upper left-hand corner. I'm trying to think how to close them out.
I think you'll be okay. It's way up at the top. It shouldn't distract anything.
Okay. I want to say at the outset that in this political power struggle that is redistricting, the stakes remain extremely high, including control of the United States House of Representatives. And in this instance, the battles are being fought particularly fiercely in Ohio and elsewhere, given the state of our political polarization. It really does feel like the continuing saga. However, this really has to end, and it has to end fairly soon. We do have filing deadlines for candidates. We have the primary, which is coming up in May, leading to the 2022 midterm elections this November. For those of you who were at the last session, I just want to share with you once more this slide about gerrymandering basics. 3 things to always keep in mind when we discuss this topic. First, who draws the voting maps? Second, what criteria are used in drawing those maps? And third, what judicial oversight is there of the results? I'm going to show you, one other slide before we get to that. So it's been said by many people, I'm going to repeat it here. When our representative democracy is working well, voters choose their leaders. When gerrymandering occurs, leaders really are choosing their voters by their power to draw voting districts, those voting maps. So I'm going to share this slide with you a couple of times. It's a roadmap. The left-hand column you see there concerns the state legislative maps for the 99 Ohio House seats, for the 33 Ohio Senate seats. So going to proceed down that list. On the right side, going to treat the congressional map for the 15 seats in the Ohio delegation to the United States House of Representatives. For those of you who haven't been able to follow this saga from the beginning, I wanted to do a quick recap. There were ballot initiatives in 2015 concerning the map drawing for the General Assembly seats, and in 2018 for congressional seats. Those ballot initiatives are pursuant to Ohio Constitution, Article 2, Section 1, which gives the people of Ohio the right to advance such ballot initiatives. It's important to consider both process and product with respect to the ballot initiatives and the constitutional amendments that came from them. As to process, we want to pay particular attention to whether there was bipartisanship in the carrying out of what the voters said they wanted, and whether there was transparency by those charged with the responsibility of drawing the new maps. I want to focus here for a moment on the 2015 initiative. Again, these are the seats for the Ohio General Assembly. Want to consider both the letter and the spirit of the law. The Ohio Constitution, as it changed with Article 11, contains multiple references to both partisan fairness and proportionality. I want to read that language because it is so important. Under Section 6A of Article 11, no General Assembly district plan shall be drawn primarily to favor or disfavor a political party. And under Section 6B, the statewide proportion, underline proportion, of districts whose voters based on statewide, state, and federal partisan general election results during the last 10 years favor each political party shall correspond closely, you can underline those two words as well, to the statewide preferences of the voters of Ohio. In addition to those considerations, there are also what are described as mechanical construction requirements. Criteria such as compactness and that governmental units such as counties and cities are not split more than they need to be to achieve the desired result. Let's take a look quickly at the 2018 ballot initiative. That became Ohio Constitution Article 19. It contains multiple references to partisan fairness, does not have the corresponding language about proportionality. But under Section 1C3A of Article 19, the General Assembly shall not pass a plan that unduly favors or disfavors a political party or its incumbents. And like Article 11, Article 19 also contains these mechanical construction requirements. So, as reported by the Columbus Dispatch last November, Governor Dewine seemed to get this. These ballot initiatives passed by 70% in 2015, 75% in 2018. And he seemed to understand that map drawing would now proceed in a bipartisan way. I will say that on October 23rd, 2021, the day of the very first public meeting and hearing of the Ohio Redistricting Commission, Governor Dewine was at the Cincinnati Bengals training camp rather than in Cleveland to hear the first witnesses. All right, back to our roadmap. So we're moving down both of these lists, and we are about to talk about the proposed Republican maps for the Ohio General Assembly. So were the letter and spirit of the law achieved as to both process and product? As to the former, I would say no. All of the final votes were along strict party lines. There are 5 Republicans and 2 Democrats on the Ohio Redistricting Commission. You see my note there that the maps are in effect for only 4 years rather than the usual 10. I won't have time to address that during my core presentation, but happy to talk about it during the Q&A. What about transparency? There were hearings, but concerns about both the number and the timing of public hearings and opportunities for public comments. A small example, when I testified on August 23rd, 2021, there was no map yet offered for the public to comment upon. As to product, the maps that the Ohio Redistricting Commission passed, again along party lines, are expected to produce a 67-32 Republican majority in the House and a 23-10 Republican majority in the Senate. Those would be supermajorities in both chambers. Let's take a look at what happened with respect to the congressional maps that the General Assembly passed. Was there bipartisanship? No, there was not. Again, all final votes were along party lines in the state legislature. Was there transparency? Again, concerns about number and timing of public hearings, opportunities for public comments, limited things happening while the General Assembly was not in session for the public to, again, observe and participate. The result is a congressional map that's expected to produce a 13-2 Republican majority. That compares with the 12-4 map, Republican Democratic, that has been in place over the last 10 years. Back to our roadmap, that brings us down to the last 2 lines in each column, the lawsuits and resulting decisions by the Ohio Supreme Court in the state legislative maps case and in the congressional map case. In League of Women Voters versus Ohio Redistricting Commission, the Supreme Court invalidated both maps because they failed to meet the partisan fairness and proportionality requirements under what I previously identified, Article 11, Section 6A and 6B. The court went on to define what constitutes proportionality given statewide voting patterns that results in a 54% Republican, 46% Democratic ratio. The court rejected the argument that what should have been counted was the number of wins in elections. Instead, it is the number of, or the percentage of votes cast for Republican and Democratic candidates. If one applies that ratio strictly, that would come out to approximately 53 Republicans, 46 Democrats in the state house, and an 18-15 split in the state Senate. With respect to the scope of the Supreme Court's order, the constitutional amendments in question do not permit the Supreme Court to draw the maps itself, does not empower the Supreme Court to appoint a special master to draw those maps. Instead, as you see here, the court invalidated the maps and told the Redistricting Commission to go back to the drawing board. It gave the Redistricting Commission 10 days to do so, and then 3 days beyond that for the petitioners to file any objections to the new maps. Significantly, the court retains jurisdiction in this case to monitor progress towards maps that more fairly represent who we are politically. I wanted to mention in particular the concurrence by Chief Justice O'Connor. I wanted to show you this paragraph in particular. She seemed to indicate frustration with political actors' inability or refusal to comply with the directives of Article 11 of the Ohio Constitution, and to suggest to Ohioans that they may want to go through the constitutional amendment process again to get a truly independent redistricting commission as exists in a number of other states. With respect to the congressional map case, Adams versus Dewine, again, the Supreme Court invalidated the map. As you see, the key language is that it excessively and unwarrantedly favors the Republican Party and disfavors the Democratic Party for no reason that would be necessary other than pure partisan advantage. The court also established under Section 1C3A that there were judicially manageable standards for Ohio state courts to apply in cases of partisan gerrymandering. This in contrast to the United States Supreme Court's conclusion in 2019 in the Rucho case, that there were no judicially manageable standards to apply in these types of cases. And for that reason, the federal courts were going to get out of the business of hearing partisan gerrymandering cases. The Supreme Court in the congressional maps case also concluded that the Republican map unduly splits governmental units, in particular Summit County, Cuyahoga County, and Hamilton County. I have a question mark as to what the numbers are eventually going to be, because the court did not say that the 54-46 ratio needs to be followed in this case. If that was the result, we'd get approximately 8 Republicans and 7 Democrats in the Ohio delegation to the United States House of Representatives. The Supreme Court, as I say, invalidated the map. The state legislature has 30 days to fix it. If the state legislature fails to do so, it goes to the Ohio Redistricting Commission to produce a map that passes constitutional muster. I wanted to conclude by sharing this first paragraph with you from the majority opinion in the congressional maps case. Beyond what I have here on the screen, in paragraph 2 of that decision, the court describes the threat to our representative democracy that gerrymandering represents. Simply put, for our representative democracy to work properly, people's votes need to count. Gerrymandering compromises that core principle. In its decision, the Ohio Supreme Court reinforces that Ohio's elected officials must respect and carry out the will of the people by creating voting districts that are free of partisan bias. I'm going to stop here and hand things over to Katy. I look forward to answering your questions during Q&A later. Thank you.
Thanks, Professor. A good overview of sort of where we've been and how we've gotten to this point, and a great place to land. I will say that it's an incredible feeling to have gotten the victories that we did at the Supreme Court in invalidating both sets of maps, thanks in no small part to the reform measures that Ohioans overwhelmingly supported across the political spectrum in all 88 counties across the state in 2015 and in 2018. I am not convinced that we would have won those lawsuits had we not passed those reforms. So I know that there will be a lot of time for conversation, justified conversation about how to improve the redistricting process. But I want to encourage folks to refrain from calling our reforms a failure, because the maps that came out of this process do not live up to them. And just offer a reminder that the language in the Constitution that was used to strike down our state legislative and congressional maps is only in the Constitution because of those reform measures. So it's been sort of a whirlwind couple of weeks since those decisions. It feels honestly like it's already been a year since they came down. It's only been, I think, 2+ weeks since they came down. A lot has gone on since then. So my part of the conversation today, I'm gonna share my screen, will be about what actually happened since those decisions came down and what is going on, I think, yeah. So I'm gonna break up my presentation to cover both sets of redraw processes. I always break down the redistricting process into 3 different phases. Phase 1 was the initial map drawing process, which Professor Glassman described in terms of how it was supposed to work based on the structure that was set up because of the reform measures. The second phase is litigation, challenging the maps that ultimately came out of the initial phase of the redistricting process. And we are now in phase 3 of the redistricting process, which is the maps being redrawn by the entities which are in charge of drawing them. So like Professor Glassman said, the court itself does not actually have jurisdiction to draw maps. It had to turn the keys back over to the Commission for the state legislative maps and the legislature and commission for the congressional maps. So that's where we are at this point. We are in further down the road in the state legislative redraw process. So we'll cover that first. And we are still in the congressional redraw process. So I'll finish out there. So first, how did the redraw process work for those state legislative maps? I'm going to break it down to talk about the timing, the hearings, and the maps themselves. So after the Supreme Court issued their opinion on January 12th, they gave the commission just 10 days to redraw the map. But 10 days are not 10 real days because lawyers have a funny way of counting days. So according to the rules of practice, they actually had, I think, 12 days to go through it because that 10-day period ended on a Saturday. But the commission itself disagreed with that reading of the rules of practice. So they gave themselves until Saturday, January 22nd, which if you're a Bengals fan was the same night that the Bengals won against the Tennessee Titans to go to the AFC Championship. So that's when that 10-day period ended. In terms of the timing for how the commission worked, they started late. The first commission hearing when they reconvened wasn't until day 6 of 10. So we wasted the entirety of the long weekend over Martin Luther King Day weekend, not even convening the commission. One shift in who was on the commission is that Minority Leader Russo, who is the newly elected minority leader for the House Democrats, needed to have been sworn in for the commission. So they needed to meet at least to do that. But that first hearing didn't happen until 60% of the way through the entire process. On that first day, we also saw a very slow trickle of proposed new maps. The first day we got regional maps from both the Democrats and Republicans that drew just 4 of Ohio's 88 districts, or counties rather. Those obviously did not offer enough of a perspective about how the Republicans particularly were really going to come up in numbers to really match that 54% Republican, 46% Democratic partisan split that is required to be reflected in the maps that were drawn. And one thing that I do want to underscore about how the constitutional language was interpreted by the Supreme Court is that the Supreme Court held that if it is possible for the commission to draw maps that reflect the partisanship of our state, it must. Not just they have to try to do so, they are required to do so. And the reason why that's important is because as activists, as litigants, we've proven that it is indeed possible to draw maps that not only meet the community split rules that govern how or if you're allowed to split cities, townships, counties, but also the rules that require that our legislative seats actually reflect how Ohioans vote. It is possible to meet all of the rules, and if it is possible, that is what needs to happen. So the first set of maps that we got were regional maps of just 4 counties. We didn't actually get full map proposals from either Democrats or Republicans until Saturday, January 26th, day 10 of 10. And there was a relatively quick adoption of the Republicans' proposed maps as the final maps. So what about the hearings in this redraw process? You know, in the initial process, the hearings that were held for the commission with the state legislative maps, almost all of them happened before any maps were proposed. So there was no way that the public was actually responding to proposed maps. We got a handful of very hurriedly scheduled public hearings on the actual maps themselves. In the end, though, actually, not a single Ohioan testified on the final legislative maps that got adopted because those were just introduced about an hour and a half before the final deadline, initially back in September. This time, the hearings weren't much better. The commission held just 2 hearings, that's it. And the second hearing where they actually adopted the maps, they actually finished adopting the maps just as the Bengals were beating the Titans. So I'm sure that you can imagine there were not a lot of Ohioans who were tuned into that commission hearing late Saturday. I'm sure most of Ohio was busy watching the Bengals beat Tennessee. And there were also no real public dialogue opportunities. Public testimony was not accepted at either of the 2 commission hearings. The only way that members of the public could offer any insight about what we needed in a redrawn set of maps was to provide public comments on the Ohio Redistricting Commission's website, something that got set up also on day 6 of 10. And those comments were limited to 1,000 characters. That's about 3.5 tweets. 3.5 tweets is not enough to effectively communicate what our communities need in future maps that dictate literally every facet of our lives in terms of whether or not folks actually represent us and our needs. So no real public input opportunities. So what happened to the maps? Unfortunately, they are still gerrymandered. Like Professor Glassman said, the court was very explicit. The maps need to reflect how we vote, and we vote in a 54% Republican, 46% Democratic split across the last decade. That should be reflected in our legislative seats. So what you should be seeing is Democrats getting at least 45 or 46 House seats, at least 15 Senate seats. Unfortunately, the new maps, even though Republicans only won about 55% of the vote, they get still a bit of a boost. They will sit in nearly 60% of our state legislative seats. When you break that down with the chamber, they're likely to win at least 20 of our 33 Senate seats and at least 57 of our 99 House seats. But one thing that I want to flag specifically about the legislative maps is what we're actually labeling as Democratic seats. The Republicans have spent a lot of time during the entirety of this process talking about the importance of creating competitive seats. They incorrectly label the impetus behind the reform measures as being that Ohioans overwhelmingly wanted a map full of competitive seats. And spoiler, that's actually not what we asked for. What we asked for is fair maps. And that means giving communities, excuse me, real representation. And in some areas of the state, yes, that means drawing competitive seats. But it does not mean only handing competitive seats to one party and shoring up all of the other seats for the other party so that there's no real competition. Unfortunately, though, that's what we got in the redrawn legislative maps. So on the House side, there are, well, let me back up and say that all in the line, the way that we define what a competitive seat is any seat that's about 48 to 52%, either Democratic or Republican, sort of that 4-point spread sweet spot. That is a competitive seat where both Republicans and Democrats could compete in the general election. On the Senate side, of the 13 seats that are above 50%, only 9 of them are above that competitive range. So 9 of them are at 53% or higher, which means there are 5 seats that actually sit in between that competitive range. If Republicans won all 5 of those competitive toss-up seats, that means that they would actually get 25 of our Senate seats, giving them 75% of the chamber when they're only winning about 55% of the votes. On the House side, there are 13 seats that are in that 48 to 52% competitive range. And if Republicans swept all 13 of those seats, they could win 70 House seats. That's 70% of that chamber. That is not a fair map. Like I said, absolutely, we should be drawing competitive districts where it makes sense, where you are seeing shifts in demographics or partisanship of certain areas of the state. So for example, a lot of the suburbs outside of major metro areas are starting to shift politically either towards Democrats or towards Republicans. And their district should reflect that, right? Your district should be fluid as your voters are. But only handing the Democrats those competitive seats does not a fair map make. So we've got to sort of peel back the onion there, and looking only at the numbers, it seems like it's great. But when you actually look at it, the maps are still a bit imbalanced and favoring Republicans. So let's actually look at how the maps compare. I zoomed in, these are screenshots from Dave's Redistricting, which is a widely used publicly available mapping tool. And I zoomed in, given that it's the Cleveland Metro Bar Association, to the Cuyahoga County region to look at both the state Senate and House maps. So on the left side of your screen, you see the Democratic Commissioner's Senate proposal. On the right side, you see the Republican Senate proposal for these counties. In terms of the coloring, this is the partisanship of those districts. So the darker the color, whether red or blue, the more Democratic or Republican it is. So those lighter shades are nearing the middle of those competitive ranges. As you can see, there's a vast difference in terms of how this region of the state, one of the bluest parts of the state, is treated under the Democratic and Republican proposals. So specifically, sort of immediately my eye at least is caught by the difference in shading of the Lorain Erie seats versus in the Democratic map versus the Republican map, right? So the Democrats figured out making that Lorain Erie seat a leaning Democratic seat, whereas under the Republican, it's a lean Republican seat. You also see a massive difference in how packed Democratic voters are inside Cuyahoga County under the Republican map versus the Democratic map. So Cuyahoga County, of course, is an incredibly, overwhelmingly Democratic county. There are some districts where it is impossible to avoid numbers of upwards of 80 or 90% Democrats in some of those areas, because that's just who lives there, right? But still, the idea of undoing the damage of our existing maps from 2011 is unpacking those voters, spreading them out among other districts so that you're not just trying to cram Democrats into as few districts as possible and otherwise spreading out the Republican votes so that you can pick up more seats. So in the Democratic proposal, you see lighter shades of blue in Cuyahoga. Of course, there are those central Cuyahoga seats that you can't avoid being relatively packed. But on the Republican Senate map that ultimately became the adopted redrawn map, you see much more packed districts. And then everything else that spreads out is either very light leaning Democratic or sinking into Republican districts. So you see that vast difference there. And you can sort of replicate this in all of the major metro areas across the state. So I will give credit where it's due. There were minor updates to the map, minor improvements to the map in terms of the numbers alone. But when you're peeling it back, did we actually achieve the promise of the reform measure, which was drawing districts that actually adequately reflect our communities? To me, the answer is no. You also see this on the House side. So again, same scenario. On the left is the Dems House proposal. On the right is the ultimate map that was passed by the commission from the Republicans. You see the same sort of difference, right? So where the Democrats found an ability to unpack the House districts to try to spread out where Democrats were, the Republicans found a way to cram as many Democrats into as few districts as possible, and then draw everything out that's in the suburban surrounding areas into Republican districts. Again, you can sort of see this all over the map. The other thing, of course, that I will just use as a disclaimer is that just because a district is a funny shape doesn't necessarily mean it's gerrymandered. The municipal boundaries in this state are wild. They are not square boxes. So sometimes that can explain why a district looks a little screwy. So this one looks a little wonky coming all the way up into here with Lake County. That's not to say that a weirdly shaped district never means that it's gerrymandered. Sometimes that's actually your sign that it's gerrymandered, that you're pulling in communities that are dissimilar for no reason. And you can see that on both maps, right? Both sets of map drawers, obviously, we're coming at this with two different objectives. But I will say, the Democratic proposals on both the House and Senate hit that 54-46 partisan breakdown on the nose. Both their House and Senate maps would have given the exact partisan breakdown for both of those. I also just want to say, I didn't include this in the slide deck, but one other thing that the Supreme Court opinion uplifted when they invalidated the state legislative maps was an expert map that had been introduced as part of the case brought under the Bennett petitioners, who are, full disclosure, petitioners who were supported by the National Redistricting Action Fund, of which All on the Line is a part. Dr. Roden's map was provided as evidence in the initial litigation to establish that it is indeed possible to meet all of the technical requirements of map drawing and also the proportional representational rules. The court actually lifted up that map as an example of a constitutional map. And both the Bennett petitioners and also the petitioners in the ACLU League of Women Voters case actually submitted Dr. Roden's map to the commission itself, providing them an example of an entirely constitutionally compliant map. And that was important for a couple of reasons. First, obviously, to again show that yes, it is entirely possible to meet all of the criteria that exist in the Constitution. It's not an excuse to say we just couldn't figure it out, but to also to use that in the objections that came later to say the commission had before them a constitutionally compliant map that you, Supreme Court, yourselves even lifted up as a compliant map, and yet they didn't go with it. They instead went with something that was less balanced. So I did just want to note that. The one other thing that I will note before I move on to go over the congressional process is one snippet of testimony that was provided. One vast difference was that both Republican mappers were actually available for public testimony, which was not true for the original process. Under the original process, Ray DeRossi, who's the Senate Republican mapper, testified a single time, and then they sort of took him back to the bunker where he normally works. But this time, both Blake Springhetti, who's the House Republican mapper, and Ray DeRossi, the Republican mapper, as well as Chris Glassman, who served as the mapper for both Democratic caucuses, were available for testimony to explain how and why they drew the maps the way they did. The line of questioning that the Democratic commissioners posed to the Republican mappers zeroed in a lot on areas where there were vast differences in terms of where Democrats found the ability to draw districts that actually reflected the Democratic nature of certain parts of the state, primarily, for example, down in Hamilton County, a Democratic county, which the Republicans sank most of in Republican districts. And they asked very pointed questions saying, how is it that we managed to figure out how to draw a Democratic district here and you did not? And the way that Ray DeRossi answered the question was, honestly, as soon as I get to 50%, I stop drawing. So as soon as I get a Democratic district to 50%, I stop. Not I stop when I realize that that district is fully representative of the communities who live there. As soon as I hit that number, I can't imagine that that specific testimony is going to be helpful for them as the court is reviewing these maps. It's not good enough for you to just hit a number and then stop. That's not what redistricting is about. Redistricting is a process essentially about the people that are supposed to be represented under these districts. So if there's a district that should be a 55% Democratic district because that's who lives there, that's what we should be drawing. Same on the Republican side. If there's a district that should be 55% Republican, that's what we should be drawing. So just some interesting things to note in terms of the differences in proposals. So that was sort of the end of the state legislative process. As Professor Glassman mentioned in his presentation, that redrawn map was finished on the 22nd. Shortly thereafter, each of the three litigant groups who were initially successful in challenging the state ledge maps filed objections to those final maps, again asserting that they were still partisan gerrymanders that unnecessarily split apart communities and undermined folks' ability to elect representatives of their choosing. The commissioners, both the Republicans and also Democratic commissioners, filed responses to those objections. The Republican response, unsurprisingly, says, no, these are actually constitutional. The court didn't require an explicit proportionality, right? It doesn't say that we have to hit those numbers. You just have to get numbers that correspond closely. That's the constitutional language, and our numbers are close enough. And then the other thing that they did ask, which we were talking about before this hearing started, made me sort of clench up with sort of secondhand embarrassment. Their last paragraph in their response brief was to actually ask the court if they could not come to a decision by February 11th to stay their involvement in this, to let the election happen in 2022 under this version of the maps, and then to come back to it after the election to ascertain whether or not the maps are actually constitutional, which is an incredible showing of arrogance, in my opinion, from the Republican commissioners. So I am waiting with bated breath to figure out when the Supreme Court will issue its opinion. It's worth noting that the candidate filing deadline for state legislative candidates was 2 days ago. So candidates across the state had to file their petitions to run for districts that don't actually exist. We don't have state legislative districts for folks to run in, but they were required to sign up anyways. So stay tuned for that. We haven't gotten a decision yet. The court's closed today because of all the snow. So maybe we'll get it next week, or who knows, maybe we'll just be running on vibes for the next 4 years. So that's the state legislative process. The congressional redraw process, the update is fairly short. There's not really a redraw process that's happening. Technically speaking, the legislature, per the Constitution, gets 30 days to redraw a map that's been struck down. We now find ourselves 10 days left in that 30-day window, and nothing really to show for it. No evidence of bipartisan work being done either behind closed doors or certainly public facing. In terms of hearings, not a single legislative hearing has been scheduled. It's unclear if any of them will be scheduled in this 30-day window. In terms of the maps, what maps? There are no Republican proposals that have been introduced. Last week, Senator McCulley, who's a Republican from Napoleon, did introduce a placeholder bill that merely declared an intent to draw congressional districts, but no map was attached to that. Worth noting that the two Democratic proposals, the first of which came from the Senate caucus back in September of 2021. The Democratic House proposal came in November of 2021. Those are still active bills. They are technically still under consideration by the legislature because they weren't voted on or passed through the committee process. So those two bills are still actively before their respective committees. I don't yet know what will happen. The one thing that I will flag, and I think, oh, I went over all of this already. So the last thing that I will say on this, and then I'll pause so that we can open it up for questions from folks, is one thing about the timing here. So normally when the legislature passes a bill, like they would have to hear to pass the congressional map, it takes 90 days for that bill to go into effect. It is now February 4th. The filing deadline for congressional candidates is a month from yesterday. So we don't have 90 days to wait for that bill to go into effect. We need it to go into effect much earlier than that. There is one workaround that the legislature has to get around that 90-day framework. They can pass an emergency clause, which would allow the bill to immediately go into effect. But the emergency clause isn't actually just a provision that you sneak into a bill. It's actually a standalone measure that itself needs a 2/3 majority vote to pass. And also the bill that it's attached to needs to be passed with 2/3 majority. So that's 66% of the chamber. Now, the Republicans have 75% of our Senate currently, so they've got that 2/3 in spades. So they alone could get that in the Senate. On the House side, though, they've only got 64 members, so they're below that 66% threshold. So they would need to not only get all of their members, but also at least 2 Democrats to vote for not only the emergency clause, but also the map itself. If history is any lesson, in the initial congressional map process, all of the Democrats voted no on the congressional map, and so did 4 House Republicans. So my guess is that they are not going to be able to get that 2/3 majority. If they are not, the process then turns over to the commission. The commission then technically has 30 days to redraw the congressional map, but they don't really, because like I said, our congressional filing deadline is on March 3rd. So they've actually only got a 2-week window in mid-February when that process turns. So now we wait. We at All in the Line, excuse me, are a grassroots organization. So of course, we will spend the next 10 days badgering legislative leaders, excuse me, to actually get to work on the congressional process and to host hearings so that members of the public can actually explain how better to draw the congressional maps. But to date, we've got no information about when or if we will have any hearings in the legislature or if there will be any legislative activity on the congressional map. So my guess is that we will likely see the baton passed to the commission, and then who knows what will happen there. So that's all that I've got. A huge thanks for folks for tuning in. I will turn it back over to you, Jay, I think, to help with questions. But thank you.
Let me ask one though, before we get to our people. What happens if nothing, it just remains deadlocked? What's the best speculation if the commission doesn't do anything, and what can I get away with, and what happens? I understand you can't tell that, but what's the best guess?
Well, there is one answer, which is that the court, of course, could hold them in contempt of court for failing to respond to a court order to go through this, redraw process. Beyond that, we're in unchartered territory. This is a brand new process. We have never gone through this process. The authors of the reforms, I'm sure, did not anticipate this level of gridlock, I guess. So there's no sort of contemplation even in the Constitution about what happens there. As Professor Glassman said, there is not explicit language in the Constitution that provides the authority for the court to bring in a special master to take over the map drawing process, which exists in some other states. But perhaps that's something that they could look into if we are in a constitutional crisis where one branch of government is just ignoring the orders of another branch of government. Professor Glassman, I'd be curious to hear what your thoughts are there too.
Katie, I agree with everything you said. I would only add that we all need to remember, as you said, we are in uncharted territory. This is a new process. This is the first time through applying these constitutional amendments, and we didn't know how that process would go. I think it's fair to say it has proceeded with difficulty. And so we arrive now at this late date with a lot of questions and not very many answers. So we continue to find our way.
Well, we've had a lot of
Sure,
questions
some
come in.
questions?
Jay,
Go ahead.
do you want
Go
me
ahead,
to help
Jay.
with the questions?
Yes, please do.
Yeah, there's been a lot that have come in. So one of the first ones we got was, is there any sign that a political group will take Chief Justice O'Connor's suggestion and pursue a constitutional amendment to create a truly nonpartisan commission on redistricting? And they admit it may be a little too soon to know.
I think Katie has a better handle on that. I'm going to defer to her.
What I will say is that there will be a lot of time for us to have that conversation just as soon as this current redistricting process is done. Our focus is on the process that exists before us. I think that there are a lot of things that we can learn from how this redistricting process went, both the failures and also the great successes of this process. But also from a human perspective, I barely have enough capacity to figure out engaging in this current process. So talking about what comes next will be something that is, I'm sure, a focus for a lot of folks, myself included, once this redistricting cycle wraps up.
Great. Another question that came in is, why did they give such a short time to resubmit maps, and they meaning the courts? It seemed unreasonable from the get-go.
The issue is one of timing in terms of the back end preparation that's necessary for the administration of the upcoming election. So the filing deadline for state legislative candidates was Wednesday, February 2nd. So the legislature itself could have moved that deadline. They did not. The court also could have moved that deadline. They did not. Folks have to know where they're running for office. But so too do the boards of elections. The boards of elections now have a behemoth of a task in trying to certify petition signatures from 132 legislative districts that don't actually exist. And there are internal board of election deadlines that exist to set up how our election is actually administered. There are deadlines, of course, for voter registration and getting ballots out to people, particularly voters who live overseas. So all of those deadlines are getting harder and harder to muck up. So there's not a lot of time for us to redraw the map. So I think that was a part of the consideration.
I would just add that there were numerous acceptable maps already available. The computer software has the capacity and does generate thousands of maps, which should have been evaluated a long time ago. So in theory, the Ohio Redistricting Commission could have come up with a map within a day. It just, that is the nature of the maps that we get to examine thanks to this sophisticated computer software.
What if the Supreme Court issues the contempt order, and as part of the contempt order, they initiate the special master? I'm totally ignorant of what might happen with that, but what happens with that then? Who can the parties opposing that go to for review?
So, Jay, again, the answer is uncharted waters. I appreciate the Supreme Court's contempt powers, but I'm still not sure that means they could ever designate a special master to draw these maps. So the Supreme Court can continue to go back to the Ohio Redistricting Commission in the first instance, the General Assembly in the second instance, to say, no, not good enough, back to the drawing board, and do that again and again and again. But I'm not sure that even with its contempt powers, it can designate a special master to proceed with map drawing.
Go ahead, Carrie. Who else?
Oh yeah, they're flying in. Please talk a little bit about the AG's decision to not allow the Democrats on the commission to retain separate counsel in the appeals.
Yeah. Go ahead.
Well, I can just start very briefly, sort of like a 90,000 foot overview. There was a decision, well, in the first phase of the litigation, there were multiple sets of attorneys who represented the commissioners. There was the Republican state legislative leaders who had legal counsel, Phil Strack from North Carolina. The three statewide had legal representation from the AG's office. And then the commission itself had legal counsel. And then the Democratic members had their own legal counsel. In the objection phase of the litigation, the Ohio Attorney General decided that the commission, all 7 members, would respond as one unit. That is, that neither Republican nor Democratic commissioners could retain their own outside counsel to offer their own responses to the objections. And there is disagreement, first and foremost, about whether that was permissible. The Ohio Attorney General responded when the Democratic commissioners offered their own pro se response, a request for the court to actually sort of recategorize them rather than being respondents, so named defendants on the header of the litigation, to being amici or friends of the court instead. And he wrongfully actually asserts that the objections were targeted at the commission as a body and not the individual commissioners, because the headers for all 3 cases named not just the commission, but also all 7 of the members individually, meaning all 7 of them are individually defendants to the case. So there's a bit of back and forth. I'm going to have to ask a lawyer who I think is smarter than me to talk about whether that's permissible to keep someone from retaining counsel if they want it. But what I will say that is distinct is how they get paid for. So in the 2019 biennial budget, the Republicans passed a measure that allowed only the Republican legislative leaders to retain outside counsel at taxpayer expense, and not similarly allow Democratic commissioners to do the same thing. There was not, though, any explicit prohibition from any other member to seek outside counsel. So I'm not entirely sure why this is allowed. So I don't know, Professor Glassman or Jay, if you have insight here, but yeah.
I really don't have anything else to add. I mean, there are so many novel questions being presented by what's occurring right now. I'm very concerned about Democrats' voices on the Ohio Redistricting Commission seemingly being marginalized in the way that they are by the Attorney General in this instance. Carrie, can I make a request?
Please.
There was a question very early on during the presentation. I will say it happens to be a question that was asked by a friend of mine out in Washington State. Was wondering whether we could go back to Steve Bernheim's question and pose that.
Yes, let me.
Should be at the very top of the Q&A.
Okay. About voters picking their representatives. Should all districts be competitive?
Steve Bernheim?
Actually,
Did the
above
courts
that.
blame both the Republicans? Is that
Yeah.
it?
Jay's got it.
Okay,
Do the
thanks.
courts blame both the Republican Party and the Democratic Party representatives for the unfairness of the map, or do the courts find one side or the other as being more responsible?
So I'd have a couple of responses to that. First, we're talking about court, not courts. The Ohio Supreme Court under both Article 11 and 19 has original and exclusive jurisdiction in these cases. So these cases went straight to the state Supreme Court. I think it's hard to blame the Democrats since they apparently had very little input, since decisions and results were along strict party lines, 5 Republicans, 2 Democrats. And I wanted to say something that I don't think I emphasized during my presentation, which was, again, partisan votes were to be only as a last resort. I think that's a fair reading of the ballot initiatives and the constitutional amendments that followed, that the public expected this to be a bipartisan process to produce a better result, a result in which our political preferences are more accurately reflected. One other response to the question, this does, to a very significant extent, come down to a battle of the experts, and the Ohio Supreme Court found the petitioner's experts more compelling and more credible.
I'll say too, just to sort of add on to the second to last point that you made, Professor, and to answer in an attempt a couple of the other questions that have come in. You are right to name that a huge intent of the reform measures was to try to rid the process of being such a partisan railroad of whoever has the dominant presence in the legislative body or on the commission, right? And an attempt to even the scales, to provide a seat at the table for both Democrats and Republicans, which is why there are necessary vote thresholds in a bipartisan manner for any map to last the entire decade. But ultimately, what needs to be driving how the maps are drawn is a collective effort to ensure that Ohio's communities are adequately reflected and represented. So a lot of times folks ask, well, why can't we just let a computer do it? The problem with just letting a computer do it is that redistricting is ultimately a process about the people. It is the people of this state who should be driving the map drawing process, not partisan interests. And unfortunately, you can't train a computer to be an expert in all of the communities that make Ohio what it is. We are those experts. And there are nuances to our communities, to our lived experiences that you cannot teach a computer. It's just something that is intrinsically human and is necessary to inject into the redistricting process. And then one other piece is about why not have all districts be competitive? The reason that you don't need all districts to be competitive is because that doesn't adequately reflect how Ohioans vote. There are parts of this state that are deep red. There are parts of the state that are deep blue. They deserve districts that represent that partisan nature, given how they vote. There are other parts of the state that are competitive one way or the other. And if that changes, right? If there are parts of the state that used to be deep red and now they're starting to be blue or vice versa, your district should be drawn in a way so that the voters dictate how that district is performing in a partisan way, rather than it being dictated by the map drawers themselves. So I, for example, live in an incredibly Democratic neighborhood. My district should be incredibly Democratic because that's who lives here. There are other parts of the state where that's not true. So it's not about making sure that every single district reflects that 55-45 split, because that would be robbing them of the representation that they deserve.
I would add that the ballot initiatives and the constitutional amendments, again, I was talking about process and product as to product. This was about achieving a result that more accurately reflects who we are politically. Proportionality is there in Constitutional Amendment 11. Partisan fairness is in both 11 and 19. Competitiveness as a criterion is not in these constitutional amendments. So in an ideal world, sure, I would love to have competitiveness as well as proportionality. But competitiveness, again, not in the Constitution, proportionality is. And it makes sense that the Supreme Court focused on that requirement. I'll also say that given the way that Republicans and Democrats have chosen to, or where they have chosen to live, it is simply very hard to create maps that score high on both proportionality and competitiveness. So again, in this round, makes sense for the Supreme Court to be focusing on proportionality and partisan fairness.
All right, well, that is our time for today. I have a lot more questions coming in, so I'm sorry we couldn't get to everything. Jay, do you have any final thoughts before we end?
I do, of course. I think we'll be back again. I hope you'll come back again with this. My guess is it's not over the next couple months. And for all the rest of you, of course, we appreciate what you've done. For all the rest of you who are there, I have to tell you that this is one of, as we go through the spring, there will be elections issues, voting issues dealt with on these hot talks over and above redistricting. There will be women's rights issues that we will deal with. We will deal with, interestingly enough, false equivalency and money in politics. False equivalency is sort of at the base of that question, is about is this partisan? Where does the partisanship come? That's a media issue. And Cleveland Marshall is doing something on policing and race, as are we in the bar also doing a diversity series. So watch for this stuff. But it'll never get better than our two speakers here, and it will never be more important. So if we come back and join us. Maybe next time we'll have 500 people. We're
Well,
set.
thank you, Kate. Thank you, Katie.
Thank
Yeah,
you,
sorry, I copied and pasted the wrong thing. What I actually wanted to copy and paste in there is our website. If you are interested in getting involved in our Fight Fair Maps, Jay's absolutely right. Our work continues. Go to allontheline.org. You can toggle over the states page and go down to Ohio and sign up. We will get you all set up and ready to go. We've got plenty of calls to action, but a huge thanks to the CMBA for this invitation. My guess is, Jay, that you're right, that we will be back with more updates. So stay tuned, everyone.
Maybe we'll be in person. Maybe we'll have lunch.
Thank
Guys,
you all.
thank you all.
Have a great afternoon.
In attendance, appreciate it.